Hi, good afternoon if you're on the East Coast, and good morning if you're out west. I saw we had a couple of folks on the registration list all the way out, looked like in Hawaii. So an early good morning to you all, if you made it. You are listening to a Midsummer update on USD rulemaking activity. That's the U.S. Department of Education, and today we're going to be talking for about an hour and a half, somewhere around there, about what's going on with the U.S. Department of Education and what is really a just tremendously ambitious regulatory agenda. My name is Lacey, and I'm a partner in the higher education practice here at Thompson Coburn. We're a big law firm. We have 300-400 attorneys and offices like a lot of these firms. We have folks out in L.A. and in Chicago and in D.C. I actually physically am in St. Louis, Missouri, and looking out over at the Arch. While folks are still joining, let me get some housekeeping done. If you have any questions during the webinar, you can submit them through the Q&A widget you see down there at the bottom of the screen, and I will try to get to those, to as many of them as I can. And I usually will stay on even if we go a little past the 90-minute mark if need be, because I like to try to get to those questions. A copy of the slide deck today is available in the little green resource widget on your screen, so please be sure to check that out and download it if you'd like to have the slides. You can also find answers to some technical questions, like common technical issues, located in the help widget. So if during the presentation your screen freezes up or something along those lines, or the slides won't advance, you might want to check out the help widget. For the attorneys that are on today, this webinar is CLE accredited for an hour and a half of general CLE credit in the great states of California and Illinois, and for 1.8 in Missouri. I don't know how 90 minutes gets to 1.8, but here in the Midwest, we do what we can. We award CLE based on attendance, so please be sure to keep an eye on the slides. From time to time, you'll be required to click a little pop-up screen to show your continued engagement. So if you're one of those attorneys looking to get CLE, you want to be sure to do that. And finally, I just want to say, we really value your opinion. We appreciate your participation and also your feedback. At the end of the webinar, there will be a survey, and if you would like to go to the survey widget and fill that out, we would be extremely grateful. We do read them, and we always try to take into consideration the comments to make each webinar better than the one before. I mentioned earlier, my name's Lacey, so I lead our higher education practice here. And our practice, just if you don't know us, we do a lot of different stuff specific to institutions of higher education. So we do regulatory counsel, meaning we cover all these regulations that the U.S. Department of Ed enforces, and also those from the state educational entities and accreditors do a lot of that kind of work. We represent institutions in litigation, investigations, administrative proceedings involving education agencies, so program reviews with the U.S. Department of Education, for example, or maybe an adverse action with an accreditor. And we do lots and lots of transactional work. So we work with schools of all types and in all sectors on things like mergers and acquisitions, but also service agreements and educational partnership and affiliation agreements and things like that. All very interesting, and enjoy working with our clients, which are you guys, the colleges and universities here in the U.S. So let's talk about the department's regulatory agenda. I have a nice fancy slide here, or at least for me it's fancy. I'm over 40, so any kind of graphic like this, I feel like I've done really good work for the day. Boy, there's just so much that they are working through, and we're going to talk through all of these today. So we're going to talk about each one of these rulemakings: accreditation, innovation, state authorization, bar defense to repayment, Title IX, and gainful employment. These are all complicated rules with lots of moving parts, and I just wanted to show them all on one screen at least once, because part of the message here is, boy, the U.S. Department of Education is busy, and if you are trying to get things done with the department, whether you're going through some sort of substantive change or you're seeking guidance, you may have noted that it is a challenge these days sometimes to get feedback. My impression is that the folks over there are working very hard. There just aren't a lot of them. In some cases, depending on who you're trying to get to, and in some divisions, they've lost personnel over the last few years. And and there are a lot of questions coming in. And layered on top of all of that are these numerous rulemakings that they're trying to get done. And, I think we tend to think about the Department of Education as this sort of huge entity in the sky with endless resources, but it's not. There are only so many folks over there, and there are even a smaller number who are really involved in, this type of high-level, complex policy making and the creation of these rules. And boy, those folks are extremely busy right now. So the way I've laid this out, we're just going to sort of march through each one of these. I am not doing an in-depth analysis of each one of these rules. You could do multiple webinars on every single one, but I am going to try to give you a high level as to what's going on, where they are right now. In each one, I'm going to focus on a particular point that I just thought would be worth communicating. I'll call it a focal point, if you will. And then also I'm going to try to give you at least some additional resources for those of you who are looking for extra credit today. So let's start with, in a sense, what I consider the easiest to get through, which is the Accreditation and Innovation Rulemaking. What's being talked about as part of this rulemaking? And when I say rulemaking, by the way, some of you probably know what I mean, but I'm sort of referring to generally the process that the department is going through to create new regulations, right? So it will typically, and there's one exception today, and that's Title IX, and I'll get there in a little while, but for all of the others, the department is going through what's called a negotiated, or has gone through, in some cases, multiple rounds of negotiated rulemaking, and that's the way the U.S. Department of Education, under statute, is required to make rules that it is promulgating pursuant to the Higher Education Act, and that's there's a little particular section of the statute that says that, and that's somewhat unique to the department. To my knowledge, there's only really one other small federal agency that is required to go through negotiated rulemaking. A lot of them can elect to do so, but the department actually has to do so. And there's always some conversation about whether or not that is something that should be revisited, right? Is it really holding up the department, or is it ultimately for the best? So the Accreditation and Innovation Rulemaking, it's a big, broad umbrella, covers a lot of different topics. Recognition of accrediting agencies and accrediting procedures. There's a lot to unpack just right there. Really what we're talking about, and again, some of you may know, but others may not, the Department of Education, of course, recognizes certain accreditors, either as institutional accreditors or programmatic accreditors. And to become a recognized accreditor, you as an accrediting body have to go to the department and seek recognition, and you have to establish that you're complying with all the various rules that the department has in place, right, for those accreditors, for any accreditor that it recognizes. So there's a section of the federal code that actually says, accreditors that we recognize have to do all these different things or require various things of their members that they accredit. And a big part of this rulemaking was the department going back and looking at that regulatory framework, right? So we're not talking about rules that apply directly to schools. We're talking about the department's rules that apply to the accreditors themselves and how those accreditors are recognized. It is important to note that in some cases, there are rules that say, if you want to be a recognized accreditor, you have to require your accredited schools to do X or Y or to show Z, right? So some of those types of things have been impacted, and there have been some proposed changes that would ultimately impact schools quite directly, right? So in other words, if one of those changes goes through, then the accreditor is going to have to revise their standards to require their members to do X, Y, or Z. The department, that was on the accreditation side. The innovation side, which is sort of a blanket term that covered a lot of different things, especially around innovative educational models and distance education. So the department is revisiting the definition of a credit hour. They're looking at how to better accommodate and approve and disperse aid to competency-based programs and programs that are based on a direct assessment model, which means, the direct assessment, especially the idea there is you're divorced from any concept of the credit hour or seat time, and it's really truly based on the attainment of competencies, which is, totally inconsistent with the way the federal financial aid programs historically have been structured, right? Everything is built around seat time and credit hour concepts. So that's a big step for the department and its efforts to accommodate those programs. Standards for distance education programs, and that one of those is actually going to be my focal point, and we're talking about things like regular and substantive interaction. And then this rulemaking also touched on a couple of other things: eligibility of faith-based entities to participate in grant and aid programs. Now, to be clear, there wasn't some sort of question as to whether or not faith-based institutions should be eligible to participate, but rather what the scope of that participation should be, and whether and to what extent certain provisions should or shouldn't apply to faith-based entities. And then finally, a revisiting of the Teach Grant program and the rules surrounding the Teach Grant program. So let's talk about where we are in terms of the calendar. The department announced this rulemaking just last year in July 2018. I think two things surprised folks. One, they already had so much in play. I think it was a little surprising that and by the way, a lot of what we're talking about today involves the department's deregulatory efforts. And what I mean by that is, this administration is looking at rules that were promulgated by the prior administration and deconstructing them or revising them. The significant thing about the Accreditation and Innovation Rulemaking is it really represented a shift of this current administration from its deregulatory efforts, right, more towards its regulatory efforts, or its it represents the things that it wanted to accomplish and change beyond just deconstructing or revising regulations from the prior administration. So they had all those deregulatory processes in place, and they came along last July and said, we got a lot of additional things we want to do. From a policy standpoint, we really want to revisit, how the accreditors are recognized and a lot of those processes work, and we have all these things we want to do around, again, sort of distance education, innovative program models. So they announced that in July, and people said, there is so much on the table here. This will never be successful. The department should break these up into different rulemakings. They shouldn't try to bite off so much. It looks like certainly more than they can chew, particularly when you take into account everything that's already on the table. And the department heard that, and they I think, attempted to do some things to accommodate that in the way of creating some subcommittees to work on particularly difficult or nuanced issues. But they ultimately decided to move forward with the rulemaking and to tackle this really broad set of issues. And they held the negotiated rulemaking. They had 3 sessions, then added a 4th due to largely inclement weather and some other issues between January and April. And for those, again, who may not be so familiar with negotiated rulemaking, that means they said, we want this group of 15, 16, 17 people, plus the folks on the subcommittees, to come to Washington, D.C. and physically sit around the table, and we're going to throw out draft language and ideas, and we want to actually try to hammer out the rules. And the goal at the end of these 3 or 4 meetings is to literally have a set of revisions and or new regulations. In a perfect world, what NEGREG is, negotiated rulemaking, is aiming for is what's called consensus. And the idea there is all of those primary negotiators, those 16 or 17 people on the main committee sitting around the table who have a vote, they will all agree to everything. So every one of the issue areas, it's like the UN. Everyone's got a veto. Everyone has to agree. It has to be unanimous. Because of that, it's a challenge to get the consensus, particularly where you have negotiators who come from very different places with regard to rules that may be under consideration. And to the department's, I'm sure, delight and credit, and for those who believe in negotiated rulemaking, I think probably to their great satisfaction, consensus was reached. So, it's interesting. In late 2018, you had a lot of comments and a lot of concern around this idea that the department was tackling such a broad set of concepts and issues, and there was real concern, how can you even get 16 or 17 people who can understand and speak to all of these issues around the table? And they did it, and they ended up getting to consensus. And what that means is the department is obligated to take that language that came out of the negotiated rulemaking and essentially turn that into the regulations with only minor or technical adjustments. That's what the agency commits to do when they enter into this negotiated rulemaking. So the department decided after they got to the end and they had reached consensus to go ahead and start moving forward with trying to get regulations out. It is, at least in my experience in the last 25 years or so, it has typically been the case that when you get a rule that you finish up negotiated rulemaking, right, and you've got this package of rules, usually you'll just see one big proposed rule that then takes everything that comes out of negotiated rulemaking and puts it out at the same time for consideration. The department's taking a different tact here. because potentially, I expect because there were so many different issues on the table, the department has decided to sort of break those apart and issue a series of proposed rules. So we've got sort of different timing here. The first proposed rule came out on June 12th, so it's already come out, and it related to the changes around accreditation and state authorization, and that's in the distance education bucket. That comment period just closed on July 12th, right? So now looking forward, and these timelines are based on every year the federal government puts out a couple times a year what's called a unified agenda or unified regulatory agenda, where they sort of say this is what our plans are for rulemaking and regulations. So these dates are based on what the department indicated in spring of this year was their timetable for these various rulemakings. So they said, look, what we're going to try to do is we want to get a final rule out on accreditation and state authorization by October of this year, 2019. And we're just going to punt for the time being. I mean, I'm sure there are people already working on it, but we're going to wait, and we're going to put out our proposed rule around all the other stuff, the innovation stuff, the faith-based entity stuff, and the teach grants. We're going to do that in December of 2019. All right? And so in May 2020, we hope to get final rules out for all that other stuff, the innovation, faith-based entities, and teach grant stuff. And then the accreditation and state authorization rules will become effective on July 1, 2020, according to this calendar, and all the other stuff would become effective July 1, 2021, right? And just to clarify, so the way the department under statute, that same piece of statute, right, that tells the department that they have to go through negotiated rulemaking and talks about some other things, also has this master calendar provision. And what it says is when the department promulgates or publishes a regulation, if it gets it done by November 1st, if it publishes the final version of the regulation by November 1st of any given year, then it can become effective by July 1 of the following year. But anything that's published in final form after November 1st, well, then it can't become effective until, the following July 1. So that's what you're seeing here reflected in this calendar, right? The department's trying to get a final accreditation and state authorization rule out by October of this year, so that it can become effective July 1, 2020. And then if it gets the final version of the rule for the credit hour, competency-based ed, faith-based institutions, if it gets all of that done in final form in May 2020, what that would mean is it would become effective July 1 of 2021. By the way, I don't have, in most of the other sections, I have a little slide here I call extra credit where I tell you can get some additional resources. I didn't put one of those in here, but I will just offer there have been a number of organizations that have done some really nice work sort of tracking the Accreditation Innovation Rule and talking about a number of the topics being covered. And just to give you a sense, I mean, NASFA, the National Association of Financial Aid Professionals, you can just Google. They've done some really nice, they have a blog, and they've done some really nice work sort of tracking this rule and talking about its implications, at least on the sort of federal financial aid front. ACE, the American Council of Education, has also done some really nice work, and you can find that on their website. For those in the career school sector, their trade association, CQ, has also done a lot of work tracking this rule and put out some content around it. So if you want to know more about, with some specificity around this Accreditation Innovation Rule, what's going on, you can certainly track those websites. It hasn't happened yet, but my expectation would be when the rules around faith-based entities come out, some of their trade associations like CCCU, for example, will also come out with some good commentary. Okay, so focal point. One thing I wanted to highlight in the Accreditation Innovation Rule, for those of you who heard me speak at NACUA 3 or 4 weeks ago, you'll recognize a couple of these slides. I wanted to talk about this topic of regular and substantive interaction. So this is of particular interest to those of you who offer programs all or in part by distance education. And you may remember this phrase because it was only a couple of years ago, not even 2 full years ago, when Western Governors University, there was a bunch of news that hit, and the Inspector General of the U.S. Department of Education said, hey, WGU owes us, I think it was, it was millions and millions and millions of dollars, right? Huge number, some just insanely large number. And the reason, sort of fundamentally, what the IG was saying at that point was, well, there's this regular and substantive interaction standard that has to be satisfied. And if you've got a program that's offered all or in part by distance education and you're not satisfying this standard, then it's not an eligible program. And that means if you've been dispersing aid to folks, then you have to give all that aid back. And their position was WGU hadn't been meeting the standard for years, and so all of the aid dispersed to all of their students had to come back, which is why you got this gigantic number. I'm sure WGU was very grateful, among others, that it was able to work things out with the Department of Education and ultimately did not end up paying that number. But it highlights the significance of this standard, right? It has been one that's been in the law for a long time. And those of you who offer programs by distance education and have ever had a program review with the U.S. Department of Education no doubt know that it's something that the department has looked at. The problem has been there's a real lack of clarity around what it, or has been a real lack of clarity around what the standard means and requires. And frankly, that lack of clarity, while on the one hand it probably is what caused the heartburn for WGU in the first place, it also is likely what resulted in them being able to deal with the issue and put it to bed. And you know, because they were able to say, look, you know, you can't require us to pay hundreds of millions of dollars back when you have a standard that lacks clarity like this one does. So one of the things that the negotiators did when they came to the table earlier this year is they said, we want to try to put a finer line, a finer box around what it means to create regular and substantive interaction between students and an instructor when you're in a distance education program. And they have, in their draft language, come up with a couple of new standards. Now, these new standards, you'll see in the lower right-hand corner, it says draft. That's because this is not, have not yet seen the proposed rule that would take this language. So what I'm basing this on is the draft language that the negotiators agreed to. But we would anticipate when we see a proposed rule on this topic in 2 or 3 months that it will reflect that draft language pretty closely. So what the negotiators came up with was this. They said, look, for regular interaction, and remember it has to be regular and substantive. But when we're talking about regular interaction between students and instructors in the program, here's what we're talking about. Providing the opportunity for substantive interactions with the student on a predictable and regular basis, commensurate with the length of time and the amount of content in the course or competency, and monitoring the student's academic engagement and success, and ensuring that an instructor is responsible for proactively engaging in substantive interaction with the student when needed. So there's a couple of important points here. I mean, one is, I think for those of you who offer distance education, you're really going to want to pay close attention to the rule that ends up the proposed and final rule, because now you're going to have some additional clarity. The department's going to continue to look at this and take it seriously, and I think it will continue to be something that in program reviews it pops up. And now you've got some additional clarity here and a new law, so I think it's going to be harder to say, well, nobody really knows what this means, right? Which, again, was sort of the not great, but available defense in years past. So if you offer distance education, you're going to want to pay very close attention to this. I've also highlighted this term academic engagement. The negotiators have proposed a new definition of academic engagement. And what I want to highlight is that it goes beyond just logging on or putting in tests. I mean, it's a real comprehensive term. Academic engagement sort of covers a lot of the different types of things that a student would do in a course. And the reason that's significant is because what they're saying here is to have regular interaction. What that means is you've got to be monitoring all of those things that constitute academic engagement, and you've got to have a system in place that would facilitate an instructor promptly and proactively reaching out to someone throughout those processes when needed. So I think there's going to be a lot of attention to distance education providers and those of you who just offer courses, maybe in a hybrid way or something along those lines. You may just have a student on campus taking a course of distance education. Every one of those courses and every one of those programs, you're going to need to be thinking about these new standards and how you can demonstrate that they are being satisfied. And that's the other thing. It's not just about doing it. It's about being able to show that you're doing it if you're ever asked about it, right? And so you got to have a way to monitor and react and also record that you did it. Okay, that's half of it, substantive interaction. The other piece is, regular interaction. The other piece is substantive interaction. And this is what the negotiators came up with. So substantive interaction between a student and a teacher, right, means you've got interaction that includes at least 2 of the following. And we have 5 buckets, right? Providing direct instruction, assessing or providing feedback on a student's coursework, providing information or responding to questions about the content of a course or competency, facilitating a group discussion regarding the content of a course or competency, other instructional activities approved by the institution or programs accrediting agency. So this is pretty flexible. You only have to hit 2 out of 5, and some of these are pretty broad. In my mind, it's the regular interaction that's going to be the greater challenge. But again, I know I've said it several times, but I just really want to stress this is not going away. It's going to be something I think the department continues to look at when they're evaluating distance education programs for Title IV eligibility, and it's something that schools are going to want to zero in on that's coming out of this current rulemaking. So next I want to move on. So that's our first, accreditation innovation. I next want to talk about the state authorization rulemaking. Now, some of you will know who are already somewhat plugged in that state authorization has started out historically on its own as its own little creature, and it in the last year got wrapped into the accreditation innovation rulemaking. But I want to treat it separately because it is significant in its own right, and there are some particular issues that have come out of this, what's being considered as part of state authorization. By the way, I just want to take 1 second to pause and say, I meant to say this at the top, but I want to give a shout out to, we had someone who registered, caught my attention from my hometown of Alexandria, Louisiana. So if you are listening today, I hope things are good along the banks of the Red River, and it is a pleasure to have someone from Central Louisiana on the webinar. Okay, back to business. So the state authorization rule covers, I'll say, sort of 4 general topics. The first is simply state authorization of distance education, right? I mean, this idea that the department has long been on the books, but that the department has really wrestled with, and that is, what does a school have to show to demonstrate that they are properly authorized in states where they have students who are taking their classes through distance education, right? So I've got an institution, I physically sit in the great state of Missouri, and I am educating students in 25 other states around the country. They're sitting there taking the class. It's an online distance education course. What type of authorization do I have to have from those other states? And those of you who have been in this space or thought about this question over the years know it's a really complicated question because those states all have different laws around what's required. Many of you also know, if you're already involved in distance education, that the sort of introduction of SARA, right, a State Authorization Reciprocity Agreement, this whole idea of reciprocity among states has been a huge godsend for schools that operate programs and educate students across many states, because if you participate in SARA, it has solved that riddle of having to be authorized potentially in 50 states or at least 49 outside of wherever you're physically located. So that's the first big component of the state authorization rule, is trying to figure out where exactly you have to be authorized and how you demonstrate that you've got that authorization to ensure that there aren't any questions about the Title IV eligibility of the students enrolled in your distance education programs. Also considered with some revisions to authorization of foreign locations. So we're talking about, a school located in the United States, domestic institution that may have locations outside of the United States. And then, and these are the 2 buckets that I really want to highlight for a minute. This rule also contemplated and has contemplated in its various iterations different kinds of disclosures that would need to be made to students in distance education programs and to students in programs that lead to professional licensure. Right, so, Masters of Education program, education program, or nursing program, or something where your graduates go out and the expectation is they're going to need to be licensed and seek licensure so that they can practice in the field, right? So this rule, this state authorization rulemaking, has a long and tortured history. It actually goes all the way back to October 2010. I'm not going to go through the entire chart, but what I will say is we are currently on, I think it's the 3rd or 4th attempt to get this rule out there. The department had one back in 2010 that it created, and then it was vacated by the U.S. District Court for the D.C. Then the department had another negotiated rulemaking that it went through in 2014, brought a bunch of people together and came up with another rule in 2016. All right, so it had a final 2016 state authorization rule that it published in December of 2016, and then that got delayed, and it was supposed to become effective last July 1, so July 1 of 2018, okay? So we had the 2010 version that got thrown out by a court, and then we had a new 2016 version, but its implementation was delayed, and so it was supposed to become effective July 1 of last year, and then on July 3rd, this administration published a final rule delaying the rule further That's the 2016 version, delaying that 2016 state authorization rule until July 1, 2020. Right? Or at least those elements of the rule that most of us are concerned with around state authorization, distance education, and disclosures. I will say, this is an important point, the department on July 3rd of last year, the delay it published did not delay the elements of the 2016 rule concerning authorization of foreign locations, right? Those foreign additional locations. So if you have foreign additional locations, just be aware that the elements of the 2016 state authorization rule concerning authorization of those foreign locations actually became effective last July 1, 2018, right? Okay, so then the saga continues. In July 30 of last year, after the current administration says we're going to delay most of the 2016 rule, all the stuff again around distance ed and state authorization, and then we're also going to do a new rulemaking to reconsider state authorization, and specifically they said as part of the Accreditation and Innovation rulemaking, we're going to wrap state authorization in, and we're going to come up with a new state authorization rule. Okay, so in August of last year, so now the department, the current administration has delayed the 2016 state authorization rule, okay, and they've announced that they're going to get a new negotiated rulemaking group together and try to come up with yet another version of the state authorization rule, okay, and then in August, you've got a lawsuit that's filed by the National Education Association and the California Teachers Association, and they sue the department saying, wait a minute, the 2016 rule is supposed to be effective July 1, and you were too late. You didn't get the delay in time. The formal delay didn't even happen until the 3rd, and the way you did it violated the Administrative Procedures Act. So in January of April of this year, right, the department goes forward and carries out its new negotiated rulemaking on accreditation and innovation. Remember, we just talked about that earlier, and a new state authorization rule is part of that. They consider state authorization, and they wrap it in, and then the negotiators, remember, reach consensus, right, and then the department publishes its proposed rule. Great. So we've got a new proposed state authorization rule that it's already out there. It came out on June 12th. It was created after the negotiators reached consensus. Aha. But meantime, in April 2019, a U.S. District Court for Northern California, the U.S. District Court for Northern California, ruled that the department indeed violated the APA when it delayed those elements that it delayed of the 2016 state authorization rule, and it vacated the delay effective May 26, 2019. So here's what I want to let you guys know. That 2016 rule, not just the portion around foreign locations, but all of the 2016 state authorization rule is effective right now. It's effective right now. All the requirements around the disclosures you have to make to students in distance education programs, the disclosures relating to programs that lead to professional licensure, that is all in effect right now. And you know what's interesting is last year in the spring of 2018, when you had that July 1, 2018 deadline coming up, everyone thought this 2016 rule was going to become effective July 1, 2018. There was lots and lots of conversation around it. And a lot of folks reached out to us. We had conversations with a lot of law firms who were putting out information and trade associations, you know, all around compliance with that rule. This year, when the rule actually became effective on May 26, it has been extremely quiet. I've heard almost nothing. I've not seen much talk about it. I've seen nothing out of the department so far talking about compliance with this rule. But just to be very clear, the 2016 state authorization rule is in full effect right now. Okay? So on June 12th, I already mentioned the department actually proposed its new 2019 state authorization rule, but it's not in effect yet. It's still in process. So looking into the crystal ball, we would expect, if the department holds to the timetable it has put out there, that in October of this year, we'll see a final version of the 2019 state authorization rule. And that 2019 version will become effective at best July 1, 2020, which means between now and July 1, 2020, schools are obligated to comply with the 2016 rule that is currently in effect, with one caveat. It is within the department's discretion, when they promulgate a rule, to give institutions the option of early implementation. And we've just seen that with gainful employment. I'll talk about that later. And what that means is, and again, it's that same statute that talks about the master calendar and all of that, you know, negotiated rulemaking, all those kinds of things. It says, look, when the department creates a new rule, it can allow schools to early implement that rule if they want to, which means they could comply with it before the rule actually became effective. So what the department could do is, if they issue this final rule in October of 2019, the 2019 State Authorization Rule, they could say, as of this issuance, schools can early implement the 2019 version of the rule and, in essence, cease complying with the 2016 rule and its various requirements. I don't know if they'll do that or not. Early implementation is complicated, particularly the more sort of complex a rule might be and the more pieces it has, but it certainly is something that's a possibility. What you should understand, though, is under almost any scenario, even with early implementation, you should be complying with the 2016 State Authorization Rule right now, and will likely have to do so for at least the next 4 or 5 months, or 3 or 4 months. All right, so what's the one thing I want to pull out of all this? Well, I just told you the 2016 State Authorization Rule is in effect, and I want to highlight the distance education disclosures you're supposed to be making right now. So the 2016 rule includes these disclosure requirements, and they cover any Title IV program. I'm in the second bullet here. Any Title IV program that's provided or can be provided completely or solely through distance education or correspondence courses. But they have this language about it excluding internships and practicums. And what they mean by that is, look, if you've got a program that's 100% distance ed but also has an internship or practicum, it's still covered by the rule, right? So we don't take into consideration those internships and practicums when you're deciding whether or not the program is 100% distance ed, okay? By the way, this also means, to the extent that you have a program that's an on-ground program and a student can take one course in the program through distance education, it's not covered. When we're focused on, that matters for state authorization potentially, but when we're talking about distance education program disclosures, we're just talking about these programs that are Title IV and that can be offered entirely or are offered entirely through distance ed. Okay, last bullet, really important point. It doesn't matter if you're a SARA institution. Let me say that again. Institutions that are party to a state authorization reciprocity agreement, SARA or otherwise, are not exempt from these disclosure requirements, right? So participating in SARA has nothing to do with whether or not you're required to make these distance education disclosures right now. So what are they? They fall into two groups. I call them the make available disclosures and the direct disclosures. Make available disclosures, and those of you who have responsibility over consumer information disclosures generally at your campus may already recognize this category, because the department, there's a lot of information the department says you don't have to hand it to someone, but you have to, quote, make it available. So, in your catalog, on your website, et cetera, and then typically the idea is if someone requests it, you should provide it to them. But the obligation is not that you're handing it out to them, one-on-one. The obligation is that you're making it readily available. So these are all things for your distance education programs, your Title IV distance education programs, right, that you should be making available. State authorization, whether the institution's authorized by each state in which enrolled students reside, or the institution's authorized through a state reciprocity agreement. Consequences of a residency change. So the 2016 rule ties authorization to residency, which is wonky. It's something the 2019 rule has changed. It was something that the distance ed community said immediately, this doesn't make good sense, but it's still in the 2016 rule, and that's the law of the land for the moment. And what it says is, as a matter of state authorization, you should be trying to figure out whether or not you're authorized in the state that the student who is enrolled claims as their state of residence. Not necessarily where they're physically sitting while they're taking your program, but where they claim their state of residence. And you need to tell them the consequences if they change state of residence midway through the program. What I mean the consequences. So let's say you've got somebody who's in your online program and you are authorized in that state where they reside, and then they move to California, for example. So you're a SARA participating institution. You say, yeah, we're good. I know we're in Missouri, you're in Kansas. And they say, well, halfway through my program, I just moved to California. You say, well, we're not authorized in California. And that's now your state of residence. You need to be telling students, making available information about the consequences of that kind of move, is what the department is saying. Also, you need to let them know the implications for professional licensure certification requirements. So let's say it's, a master's of education program or a nursing program, and you are confident, again, we'll say our school is in Missouri and the student's currently a resident of Kansas, and you say, well, we know that if you graduate from our program, you can be a nurse or a teacher in Kansas, and then they move to California. Turns out your program, graduates of your program, can't be a nurse or a teacher in the state of California. Well, you got to be prepared to let students know that kind of thing. That's what the department is saying. And by the way, you're going to see when I talk about the 2019 rule here in a minute, I'm going to give you a one-slide preview. But the general comment I want to make is, this is a major concern for the community of regulators, for policymakers, that, we've had this sort of growth and development of online learning over the last 15 or 20 years. But one sore spot has consistently been that folks are enrolling students in the programs, particularly around programs that lead to professional licensure. And then the students get to the end of the program and they find out that they can't actually do whatever it is they were prepared to do in the state where they reside. And regulators feel strongly, and it's, almost, I'm sure there's someone out there who will argue differently, but I agree, right? I mean, we need to let students know where they're going to be able to get licensed and practice when they graduate from the program. And the feeling is that information has not been readily available. The thing is, it's complicated, and knowing whether your program will enable someone to practice in that profession in every state where you might have a student who enrolls, it's complicated, and you're going to have to figure out a way to monitor it on an ongoing basis, because those laws or requirements can change, and your program may not change in real time. Right? I'm just telling you, this is something, if you offer distance education programs that lead to professional licensure, you're going to have to invest in and be ready to do. Right? And if you don't, it's not just the U.S. Department of Education you got to be worried about. It's plaintiffs' attorneys and state AGs and others who are going to say, look, you enrolled a bunch of our students that graduated, none of them can actually do what you trained them to do, and you didn't tell them that on the front end. And now we got a Consumer Protection Act claim or something along those lines. So prepare to invest in these resources. Even apart from what ultimately happens with the 2016 State Authorization Rule, I'm just telling you, this stuff is here to stay, and you're going to need to be on top of it. Okay. Description of complaint processes. So they want you making available for students information about how your online students can file a complaint if they're unhappy. Historic adverse actions. So you're supposed to be making available any adverse actions a state or accreditors initiated, including years initiated, relating to these programs over the last 5 years. That's, I think, going to be surprising to a lot of people. Refund policies with which the institution has to comply in any state in which its enrolled students reside. Remember, we're talking about the 2016 rule, which is attached to residency. And licensure and certification prerequisites. And this really goes to everything that I was talking about a minute ago. They want you, for each of your solely online programs, providing students, again, doesn't have to be handed to them directly, but on the website, making available information about educational prerequisites for professional licensure or certification in any state where enrolled students reside, or the institution's made a determination regarding such requirements, whether the program satisfies those prerequisites, and for all other states, they want a statement that you haven't made a determination. So there's a lot to keep track of. And this is why last spring, in advance of that July 1, 2018 effective date, folks were really hustling over this and concerned about it. And again, it's been a little surprising to us that there hasn't been much discussion since this thing became effective in May of this year. And my gut is that's because a lot of people just aren't aware that it's now in place. Direct disclosures. So those are all the make available disclosures. There are some direct disclosures that you have to make to students in your online programs. So to prospective and enrolled students, any determination by institution that their program ceases to meet licensure or certification requirements. So let's say, again, we go back to this model where I'm sitting in Missouri, my school's in Missouri, I got a student who's in Kansas, and we're totally confident that our program allows graduates to be licensed in Kansas, and then Kansas passes a new law, and they change the requirements, or their regulatory agency, promulgates some new regulations. Now we have to let folks know if we've made a determination that we no longer satisfy their requirements, and that has to be a direct disclosure. Notice of new adverse actions, to prospective and enrolled students, any adverse action initiated by a state or accreditor with regard to the program within 30 days. And to prospective students, just prospective students, prior to their enrollment or registration, any determination that the program does not meet licensure or certification prerequisites in the student's state of residence. So there's a lot of work to be done here, and it may just be for a few months, but for now, this is the law of the land, and I really wanted to draw this out for folks. Previewing the 2019 state authorization rule, just a couple of big things that would change, 2 or 3. First of all, it would require the institutions be authorized in the state in which the student is located. So we ditch this idea of residency and we move to where the student is physically located, which comports much more cleanly with sort of the ideas around physical presence and contact and minimum contacts, those kinds of things. The bulk of those disclosures that I just talked about, those distance education program disclosures, would be dumped. Okay, so the bulk of those would be dumped entirely once the 2019 rule either becomes effective or you're allowed to early implement. But, and this is the last thing I hit on earlier, I want to emphasize again, the disclosures relating to professional licensure, not only would those remain, but they would be moved out of the distance education bucket and apply to all programs without regard to whether they're offered online or on ground. So to be clear, when that 2019 rule becomes effective, what the department is saying is you need to be making available, not direct disclosure, but making available to students information around professional licensure and your programs, whether they are online programs or on-ground programs, because these concepts, whether programs are really getting folks to the place they need to be to practice, are extremely important, and they should know on the front end before they enroll in your program. Extra credit. So if you're interested, we did a webinar on the 2016 State Authorization Rule last spring, and it covers in great detail all of the stuff around the 2016 rule, including some of what I just chatted about, but it gives a lot of we get into the weeds using some guidance from the department and from the preamble to that rule. We get into the weeds on some of the types of issues that come up when you're really trying to put this thing into practice. We also give some suggestions on how potentially to approach implementation of the 2016 requirements. It's free and on demand, so you can just go to our website and knock yourself out. All right, the borrower defense rulemaking. So we've talked about accreditation innovation. We've highlighted state authorization. Now we're moving on to something completely different, borrower defense. Some of you know I was a negotiator actually for the most recent round of negotiating for the borrower defense rule, so this is a rule that is particularly near and dear to my heart. And it is another one that covers a lot of different areas. The headliner you always hear about and folks talk about is this framework pursuant to which borrowers could potentially discharge their loans based on a claim that their school did something, right? Whether by act or omission, you misrepresented, you breached a contract, you name it. It sort of differs based on the different iterations of the rule. But fundamentally, the idea is I'm a borrower, and I say, you know, my school did X, Y, or Z, and I shouldn't have to pay back my loans, right? So that's the core idea around the borrower defense rule and often what is discussed. But this rulemaking addressed a lot of other things. One of the really significant add-ons was a revision of the financial responsibility framework, including adding a number of new reporting requirements, and that's going to be our focal point here in a minute. It also touched on closed school discharges, false certification discharge, a new definition of or revisions to the definition of misrepresentation that exists in the regs, pre-dispute arbitration, class action waivers, and there was a repayment rate. And some repayment rate reporting that the department introduced as well. And I'll just emphasize, you know, I say this all the time. I hear others in this, attorneys and compliance folks in the space say this, but I still sometimes don't feel like it has completely caught on. There are only a couple of pieces of this that are specific to or would only apply to the career school for-profit side of the house. Every other bit of this applies to all of higher education. So all institutions of higher education, all sectors, are subject to the borrower defense claim process, to the financial responsibility reporting requirements, and a lot of the other things in here around closed school discharge, false certification discharge, et cetera. So it's definitely worthy of attention. So what's going on with this rule? This is another one that there have now been, just like state authorization, there have been 3 tries at it. Right. So there was originally, way back in 1994, Congress changed the law, the statutes, and they said, hey, Department of Ed, we rolled out this direct loan program, and we want you to tell folks, borrowers, when they can assert a defense against having to repay their loans. Like what is it a school would have to do so that someone wouldn't have to pay back their loans. And Congress basically said, Department, we want you to tell us that and issue rules that sort of articulate that. So the next year in 95, the Department came out with a very small sort of discrete set of rules. And then, 20 years went by, and no one really had any claims. I think, I've heard different numbers, but it was, if not single digits, low double digits, 10, 11, 12 claims that were ever filed. And then you had the collapse of a couple of very large career school groups, along with just sort of some general distress in higher education that resulted, frankly, in all sectors, has resulted in some closures and winding downs. And you got all these bar defense claims. And I mean, hundreds of thousands. And the prior administration said, we do not have a regulatory infrastructure in place that will allow us to manage all of these claims. And anything even approximating an efficient process. So in 2016, the prior administration said, we're going to carry out a negotiated rulemaking, and they did that, and consensus was not achieved, but as is the Department's right, they went forward and published a final rule, final bar defense rule, November 1st of 2016, with an effective date of July 1, 2017. And then shortly thereafter, we had an election. I do want to point out, on the day before the inauguration, in January 19th, 2017, the Department published some procedural rules governing its ability to recover against schools where it has already granted a discharge. So you sort of have two processes. You have the process by which the Department determines whether or not to discharge a rule or discharge the loans. And then you have a secondary process through which the Department seeks to recover against schools whatever amount it may have discharged. Those procedural rules actually went into effect right away, the ones that were promulgated January 19, 2017, and they remain in place right now. So they are not part of all of this. They're on the books. But with regard to the bulk of the rule, all the stuff on the prior slide, right, everything else, it was in final form and it's supposed to become effective July 1, 2017, and then there was a lawsuit. California Association of Private Post-Secondary Schools sued the Department saying, hey, that 2016 rule violates the APA. And the Department in June 17, right before that rule, the 2016 Bar Defense Rule is supposed to become effective, it published a notice delaying big chunks of it. So that July 1 date came and went without the 2016 version of the rule being implemented. Okay, so in the interim, just like with our state authorization rule story, we have a similar story here. In the interim, the Department said, hey, we're actually going to put together a new bar defense rule. So we've delayed the one the last administration did, and in the interim, we're going to go through a new negotiated rulemaking, and that was actually a negotiated rulemaking that I participated in. So I was one of those folks who went to D.C. and sat around the table and tried to come up with a new rule. That happened between November 17 and February 18. And then, and in the interim, somewhere around there, the Department said, hey, we're going to delay the 2016 rule even further out. And then July of 2018, they published, this administration published its proposed bar defense rule to replace the delayed 2016 version. But then the story gets, the intrigue increases. In September 2018, U.S. District Court for D.C. said, hey, when the Department delayed the 2016 bar defense rule, they violated the APA, right? And on October 16th, they at the same time said, we don't think that the CAPS lawsuit has legs, right? And that could still come back around. There really wasn't a decision on the merits there, but that pretty much opened the door for the 2016 rule to become effective, which it did in fall of 2018. Of course, that left a lot of schools in the lurch because you now had this new bar defense discharge process. But remember, I mentioned the financial responsibility piece, and there were all these reporting requirements that schools had, and now apparently that they should have been reporting. You had all these events that should have been reported since July 1, 2017, and it was totally unclear how you should go about reporting, to whom you should report, what you should report, and for that matter, who exactly was subject to the reporting requirements. There was a real open question as to whether or not public institutions were even covered. So there was so much that was uncertain. And the Department said, hey, we're going to let schools know. We're going to get some guidance out shortly. And several months went by. And on March 15th of this year, the Department finally published some material guidance designated as such, letting schools know how to comply with those financial reporting obligations under this under the bar defense rule. And I really shouldn't refer to them as I should not refer to them just as financial responsibility reporting obligations, because they're actually two sets of reporting obligations, one that fall under the revisions to the financial responsibility framework, and some additional obligations that actually pop up in a different part of the regulations. But the salient point here is schools now had to comply, and now, as of right now, today, have to comply with these various reporting obligations. And there is guidance at this point out there telling them how to do so, and everyone is required to comply with these. On June 3rd, the department also published some additional guidance. By the way, all of these, you see the bright blue underlined, those are all active links in every one of these calendars that you can click on if you download the presentation, and you can go to all the underlying documentation or whatever the link sends you to. So it's just sort of, if you're interested in doing a little more work on some of these or looking into things, it puts it all together for you more or less in one place. So looking forward, we just established the 2016 Bar Defense Rule is in effect right now, just like the 2016 State Authorization Rule. We anticipate that the department, they've indicated that they expect to publish their final 2019 Bar Defense Rule in the Federal Register by September of this year. And word on the street is that rule has already made its way over to OMB for review. So it seems like the department's pretty serious about making that happen. And people are going up to OMB to talk about why they don't like the rule or why they do like the rule, et cetera. And the idea is to get it done no later than November 1st of this year so that it can become effective July 1 of 2020. Now again, and the question I always get is, well, what about early implementation? If we get a new bar defense rule in September, October, November of this year, could the department again allow schools to early implement all or portions of that rule? They could. But I will also note that the bar defense rule is pretty darn complicated, and it could be quite difficult for the department to figure out which pieces to designate for early implementation and how to record that and how to make it work. It could be that the department just says, you know, it becomes effective July 1, 2020, and we're going to leave it at that, at least as far as some of the reporting and other obligations go. But as with the state authorization rule, I mean, what schools need to understand is, best case scenario, the 2016 bar defense rule is in place right now and will remain in place until at least September, October of this year, and that's assuming an early implementation option. I think more likely, if I were tossing the dice here, I think you're going to see that rule stay in place until July 1 of 2020 next year. Maybe they give some relief on the reporting obligations. That does seem like it would be amenable to an early implementation concept. But one way or another, you're stuck with the 2016 Bar Defense Rule for several more months and need to be paying attention to these reporting requirements. Speaking of which, that is our focal point. I'm going to go through this pretty crisply. As many of you know, we've covered this before in a webinar we did just earlier this year. Folks who may have seen me at NACUA, we talk about this at length too. But I did want to at least hit on it briefly. So the 2016 rule is in effect. I've said that 12 times from Sunday. It's important to note. And you've got these reporting obligations. The financial responsibility framework, by the way, just so you understand how this fits in, right? I mean, schools have to establish, along with being administratively capable, they have to establish that they are financially responsible. Those are sort of conceptually the two big things that a school has to show to participate in the Title IV programs. And financial responsibility, the department under the 2016 rule has augmented the historic framework, and now it's sort of got 5 different buckets of things that you have to show to be financially responsible. 4 of those, the things on your screen that are gray, have been around for a long time. What they did here is they created a new bucket, this sort of large bucket of meeting financial obligations and providing administrative resources. And then what they've done is they said, so to show us that you are satisfying this new standard, this new criteria that we've added in, you have to report certain things to us, and we have to determine that those events, if they've occurred, aren't material to your bottom line, your financial responsibility. So it's sort of a neat way within the framework of creating a new monitoring mechanism where they are told more frequently about events that are happening on campuses and have the opportunity to decide whether or not they implicate the school's financial responsibility. of the things that have to be reported to the department, those things or events are sort of divided into three different categories. There's one set of events that if they occur and you report it to the department's actually going to recalculate your composite score. And the idea there is they're using the composite score as a means by which to determine whether or not the event you reported is material, right? So if you have a piece of litigation or a claim against you, settle it for $1,000, you've got a $500 million endowment. I'm curious as to whether or not the department would actually recalculate your composite score, but if they did, clearly it would show that it is not material, right? So it's a mechanism for determining the materiality of the event you reported to your financial bottom line. They have another middle category, just a handful of events that if you report, it's just automatically considered material. These are events largely impacting publicly traded institutions and that most folks won't deal with. And then there's this last bucket of discretionary events that the last administration, remember, is the one that created this rule. They seem to contemplate a lot of new things, but several of them that fall in this category don't even exist, like different kinds of rates or metrics that the administration was envisioning that they would create. So I don't expect a lot of activity under this discretionary bucket, at least with this administration. All right, so the color coding holds here. The stuff in gray, those are the things that if you have it and you report it, if it occurs and you report it to the department, they would recalculate your composite score. Judgments and settlements, BDR litigation initiated by a federal or state agency, any other litigation that you have, a creditor teach-out, events that required that you provide a teach-out notice to your creditor, an at-risk gainful employment program, qualifying withdrawal of owner's equity, et cetera, et cetera. Okay. I'm just going to focus on the final judgments and settlements real quick. So here, let me go back. These first two, the first one, final judgments and settlements, and the third one, other qualifying litigation. All I'm going to do, I'm not going to go through all these in detail, even though I have several slides here, but what I really want to focus on and emphasize is, and I've had a lot of conversations with schools over the last 5 or 6 weeks around these two items, right, including a lot of schools in the traditional side of the house, traditional higher ed. The first final judgments and settlements, the department right now, based on the guidance that's made available, including a little bit of commentary it put out on June 3rd, and remember I have a link to that in that chart 2 slides back. The department, at least as of right now, seems to truly be contemplating that any settlement you have, right, whether it arises from an actual judicial proceeding or administrative proceeding, or potentially from any other claim, even if it hasn't been filed, if it's just been threatened. So you get a lawyer letter, so we're going to sue you for, $10 million. And by the way, no materiality threshold here, no consideration as to the underlying nature of the claim. Doesn't have to be a Title IV claim, doesn't have to be a bar defense claim, could be a sexual misconduct claim, could be a tort claim, it could be a slip and fall in your parking lot in front of your administration building, right? Doesn't matter. What the department is saying is, if you settled, we want you to report it to us, right? And the reason it doesn't matter, the nature of the underlying claim doesn't matter, is because remember, this is about financial wherewithal. The department just wants to know if there's been an event that implicates your financial stability. So it doesn't matter if it's a sexual harassment claim or a slip and fall. If you paid out $12 million and you're a small school, it could impact your financial responsibility, right? So the department is saying, we want to know. Now, that's going to ultimately be reflected in your financial statements that you provide to the department. But their point is, and the whole philosophically, part of what was behind this rulemaking is, things are happening between audits. And sometimes those things happen and impact a school quickly, and we want to know about them. So right now the department's position is, if it's a settlement, we want to know about it. It does not necessarily have to stem directly from a claim that's been filed in court or an administrative proceeding. That having been said, I know I've been in conversation with the department. I know others who do the kind of work that I do are chatting with the department. I've gotten a lot of questions from you all in the community that I've been forwarding to the department with specific examples. And what we've suggested is the community really needs a lot more clarity around this definition of settlement. So, we understand that the settlement may not need to flow from an actual claim in court or an administrative proceeding, but we still need to know what exactly you mean by settlement. I mean, if we agree with an unhappy student to write off the tuition that they paid in for a particular course, I mean, is that a settlement? One would think no. Well, what if you have a student that leads the school and we have them sign a release, and like at the top it says settlement and release, right? I mean, there's been no lawsuit. There's no claim. Is that a settlement? What about, I mean, I had someone even ask me about potentially like severance agreements and things like that, where you might have an employee that leaves on less than desirable terms, and you have some sort of settlement document. And I've advanced these to the department, and I've said, look, we don't think all of this is what you're contemplating or should be what you're contemplating. We think really what we're talking about here is claims, threatened litigation in the least, if not actual litigation, and we think you need to draw a tighter box around that. Otherwise, you're going to get millions of non-material things reported to you, and that's not good for anybody. It wastes our time and it wastes your time. So that conversation is happening, and I hope to get more clarity around this issue of settlements. The other really troublesome bucket is other qualifying litigation, and I know a lot of schools were quite surprised to learn that the department is truly requiring and expecting institutions to report all their litigation. So any claim you get, and I know for, large public systems and large private nonprofits where you have hospital systems and things like that, I mean, you get all kinds of litigation. As of right now, the department is saying, yeah, all of that needs to be reported to us. Provided certain thresholds have been met, right, around summary judgment. So I'm not going to go into it in great detail here. I will just offer that, and I'm going to highlight here in a minute. We did a webinar, 3 or 4 weeks ago where we went through all of this in great detail, and we talked about some of these challenges. Again, the department has subsequently on June 3rd put out some additional guidance, and we have a reporting guideline document that I've got on a slide here in a couple of clicks that you are also welcome to look at. The main thing I just want to highlight is, there are a couple of categories here that we know are troublesome. I think the department knows that they are troublesome, and I'm hopeful that you will get more clarity and guidance in the coming days around some of these issues so that schools will have a better sense of exactly what needs to be reported, and for that matter, how it should be reported. Right now, all of this really just goes into an email address, and there's no format for how it's supposed to be reported, so my expectation is that how schools are reporting varies widely. The other thing I will indicate, and those who are at the NACIO conference heard this firsthand, but there are schools that are getting responses from the department who reported information. Now, I don't know if that's piecemeal. I think it is. It does not appear to me to be systematic. Most of the schools I've talked to have not heard anything back, or they got a 2-word email, but at least a couple of folks have reported that they got significant feedback from the department and requests for further documentation. So just keep that in mind. Okay. The other thing I just want to emphasize again, so I mentioned earlier, you've got this set of reporting requirements that falls under the financial responsibility framework. There are separate reporting requirements for judicial and arbitral records if the underlying claim is a bar defense claim. Right? In those cases, and this is in a different set of the regulations, it's not part of the financial responsibility framework, it's in the regulations that govern the terms of your participation in the direct loan program, or specifically the regs that say what has to go in your direct loan participation agreement, right, that every school has to sign. So those regs were amended, and that agreement, therefore, was amended to provide that if you get sued, or if someone's trying to arbitrate with you and the underlying claim is a bar defense claim, then you have got to provide actual records to the department. And this department, in its March 15th guidance, provided an email address, and they said, this is where we want you to send it. The riddle here that I think schools have got to contend with is whether or not you think the underlying claim is a bar defense claim. And what's interesting is the department has said, and I'm just going to click through these slides. You can look at them. There, by the way, is the email address where this stuff is supposed to go, and the timing requirements are here. But the thing I wanted to highlight actually is here on the second bullet, or the first bullet. It says the regulations. In the regs, it says whether a claim is in fact a bar defense claim is ultimately to be decided by the court that's considering the matter. So what's interesting is, the department is saying almost right away, within 30 days, you've got to send us these records if the underlying claim is a bar defense claim, but it could be months, if ever, before a court actually decides on whether it is a bar defense claim or not. And what's interesting is the regs, while you would think it's clear, they really aren't clear. There's a pretty broad, there's a lot of latitude for interpretation as to what constitutes a bar defense claim. So I think schools are going to have to decide how they want to comply with the reporting requirement. I mean, one option is just not to report and to take the position until the court decides that, either you don't believe it's a bar defense claim or you don't think it could be, it's uncertain. Another option would be to report the documents but reserve and say we don't think it's a bar defense claim, but we're reporting out of an abundance of caution. There are a number of different ways you can go, but if you've got a claim that ostensibly is a bar defense claim, so someone is saying, they're claiming misrepresentation or under the 2016 rule, a breach of contract, you're going to have to make a call as to how you want to satisfy this particular reporting requirement. Previewing 2019. So that's all under the 2016 rule that's in effect right now, right? We've got this new 2019 rule we expect to go final in September, October of this year. It likely will introduce a revised federal claims standard that will only recognize claims based on a new federal definition of misrepresentation and will require at least reckless disregard on the part of the institution. So right now, an institution, the way the 2016 framework works, ostensibly someone could have their loans discharged if there was something that was false or misleading that the institution did or said, even if it was a mistake. And all the parties agree it was a mistake. There is no intent concept in the 2016 rule. Whereas in 2019, this administration said, look, I mean, institutions, this administration has said we don't think schools should be penalized for mistakes. In other words, there has to be some level of intention or reckless disregard, among many other things. The 2019 rule will probably set forth a much shorter list of reportable events. So all the stuff we talked about earlier, we don't expect to be there. The proposed rule didn't include any of those things. The proposed rule focuses much more on quantifiable expenses. So they still want you to report settlements, but they don't want you to report claims and litigation because the claims are just that. They're claims, right? But if you got a settlement, you've paid it out. So the 2019 rule is more focused on reporting actual quantifiable expenses that have been incurred. And it will finally likely include new potentially significant provisions relating to the treatment of operating leases and the use of long-term debt, in each case in the calculation of the composite score. I'm not going to go into that right now, but if you would like to learn more about those things, we have our reporting guide, which you can click right here and get on reporting timeframes and the submission requirements, but also we did a webinar a long time ago, way back in the December, I think, of 2016, we did a webinar that reviewed in detail the 2016 bar defense requirements that are in place right now, and we broke them down and talked about all these different things. So you're very welcome to go back and listen to that webinar. Okay, Title IX rulemaking. So I've laid this one out in a slightly different way. And boy, if you're not paying attention to Title IX, I think folks on the traditional higher ed side of the house pay a lot of attention to Title IX. The smaller schools, career schools, I don't think have paid quite as much, but there is a lot going on, and I definitely encourage you to stay plugged in. So as most of you know, when we talk about Title IX, we're talking about Title IX, the Education Amendments of 1972. What's interesting is, and I wanted to talk a little bit about the history of Title IX and its rulemaking because there are some real lessons that have been learned out of the way things have been handled over the last decade. And I mean lessons learned by everyone, both whether you're Republican or Democrat. I think everyone has figured some stuff out here. So what's interesting is you had the statute in 72, and then in July of 75, the department published its regulations, right? So 22 years go by. 22 years go by, you have no new rules, right? And then the department publishes a guidance document, sub-regulatory guidance, on sexual harassment guidance, covering harassment of students by school employees, other students, or third parties, okay? Next 2 years, there are a couple of Supreme Court cases that come out where folks are trying to enforce, they're essentially suing their schools, and they're claiming a private right of action under Title IX, and the court's got to decide, what does someone have to show to demonstrate that their school failed failed to comply with the requirements of Title IX, right? So then in 2001, on the heels of those two decisions, the department comes out with another piece of significant guidance on this topic of sexual harassment. And by the way, I mean, there has been other guidance along the way that relates to equity in athletics and other issues that are covered by Title IX. I'm really focused here on guidance and rules around the management of sexual misconduct on campus, right? So you had this period from, this 22-year period where you had nothing, almost nothing out of the department, no new rules and very little new guidance, a couple of Supreme Court cases. And in 2001, you get a significant, another material, significant piece of guidance from the department relating to sexual harassment, sexual misconduct on campus. And in that, interestingly enough, the department drew a distinction between what the Supreme Court had said someone had to show to demonstrate as a private right of action against an institution, and what the department considered its standard, its administrative standard for determining that a school had failed to comply with Title IX. So the department said, look, we've got the right to create two different standards. If someone wants to sue you in court, the Supreme Court has said they got to show X, and we're okay with that. But for our purposes, we can find that from an administrative standpoint, you have failed to comply with Title IX if you have failed to do Y, and that's a different standard, right? So then another 10 years goes by, and things sort of explode, right? And most of you, particularly if you're in traditional higher education, are well aware of this, right? April 2011, April 2014, you get lots of new guidance out of the department, detailed, extensive, all around the management of sexual misconduct on campus. At the same time, the department ramps up its investigations and oversight of how institutions are managing sexual misconduct on campus, and the number of active investigations with the Office of Civil Rights just goes through the roof. And then in May 2016, the department also steps in and gets very specific about treatment of transgender students and employees on campus and those obligations under Title IX. Now, those of you that follow discrimination law will know that the Department of Education and the EEOC much earlier than 2016, going back, I think, to 10, 11, 12, 13, and for the department 14, had already started enforcing decisions and including in small places and guidance their view that transgender individuals and discrimination based on gender was covered by Title IX. But May 2016 was the first time that the department really aggressively put this out there, and they issued this significant guidance that was specific to this topic, right? So then we had an election. Okay. And almost a year goes by. And in February 2017, this administration publishes a Dear Colleague letter that just rescinds that May 2016 guidance, right? And adds some additional commentary, right? But from a practical standpoint, more or less rescinds the May 2016 guidance. And then in September 2017, they publish another Dear Colleague rescinding the April 2011 and April 2014 documents. So the lesson that was learned here, right, and this isn't just at the U.S. Department of Education. I think it's probably across a lot of agencies, and administrative lawyers will talk about this. But the big lesson that's been learned here is, the problem with sub-regulatory guidance and not creating law is that it's just so easy to undo. It's just guidance. And so with subsequent guidance, an agency can take it off the books. So what this administration then had decided to do is to actually promulgate new rules under Title IX. Now, one of the things I think is worth noting here is, remember, the last time we saw rules around sexual misconduct were the year after the statute itself was created, right? So it's been over 40 years. And these are the first real material rules around sexual misconduct under Title IX that have been promulgated in that entire period. All that other stuff we saw in those prior charts, right, even going all the way back to 1997, all guidance documents, right? Now, the 2001 guidance, I will note, does remain in effect. This administration did not repeal the 2001 guidance, and it is quite significant and robust, in a lot of ways. But what this administration has done is it said, we're going to do a new rule. Now what's interesting is they don't have to go through negotiated rulemaking. You say, Aaron, you just told us the department has to go through NEGREG. The department has to go through NEGREG anytime it's promulgating rules that are authorized under the Higher Education Act. But Title IX is not part of the Higher Education Act, right? It's not in the Title IX of the HEA, right? So in this case, the department doesn't have to go and promulgate the rules pursuant to negotiated rulemaking, and similarly, they are not bound by the master calendar that governs how those rules go into effect and when they can become effective. So the whole November 1, July 1 of the next year stuff doesn't apply here either. So what did this new proposed rule cover? Man, everything, right? I mean, it updated some key definitions, but it added new definitions, and it essentially would implement a massive new framework for how schools are supposed to manage sexual misconduct on campus. And it's interesting because you will see, and this is not, I want to be real clear, I'm not making a political statement here, but it's just, this is from the perspective of an administrative law attorney, right? It's interesting because, some of the political rhetoric out there, and it is rhetoric, right? Because this is a huge emotional political issue. Make no mistake, we all know that. And so it's by design, it is intended to be political rhetoric. But, there's a lot of discussion about how this rule would strip away or undo or undermine the Title IX statute. I mean, from a strictly, again, regulatory standpoint, there aren't any rules currently on the book. What it does is, though, it takes a different view and would implement different rules or implement different ideas from the guidance that was promulgated or published by the prior administration, right? So there was all that guidance, and there were a lot of, the prior administration said, we think to comply with Title IX, when you're managing sexual misconduct, it should be done this way. But again, that wasn't a rule. So really, one way to look at it is, this rule from a strictly regulatory standpoint isn't really stripping away anything. It's plugging in a ton of new requirements that don't currently exist in the law. At any rate, you can take whatever view you want on it. At the end of the day, the important thing to note, and if you are an administrator, an institution of higher ed, and you have looked at this proposed rule, it's a bear. It's a bear. It's not some sort of cakewalk or free pass for institutions, right? So what's going to happen with it? Well, I think it's highly uncertain, to be frank. I mean, the department has said they are committed to getting a new final Title IX rule out in September of 2019. But we've covered, they're already managing this incredibly ambitious regulatory agenda. The agency is understaffed and unhappy. Those are live links. You can go to articles about how understaffed and unhappy they are. They got over 100,000 comments. I heard 120,000, something like that, and they have to review them. That's their obligation. The Democrats have vowed to fight this proposed rule, and also the Democrats in Congress very much want revisions to Title IX and a lot of these things to be addressed in the reauthorization of the Higher Education Act, which is ongoing. In fact, one of the reasons, and I've heard through the grapevine, maybe the primary reason you aren't seeing a reauthorized higher education bill is because of Title IX. Because, even though there's less, in many cases, around, sort of the FAFSA and simplification of the FAFSA and a lot of these other sort of nuts and bolts financial aid issues, they could probably get there on a lot of those. But the problem is the Democrats want Title IX to be part of a comprehensive reauthorization bill, and Title IX is a sticking point among folks in Congress. The other thing is the department is going to want to make dang sure that it defends its title. Every time this administration has promulgated a rule, they've been sued, right, for the most part. And the prior administration got sued quite a bit as well, right? So when they promulgate these rules, part of what they're doing is, in these preambles, these massive, 80-page preambles, is they are building their case. Because what happens is when they get sued under the APA and the court looks, the preamble is where the court looks to see if the rule was arbitrary or capricious, or if the promulgation of the rule was reasonable. All of that, they're looking at that argument that the department has made. So, you got 120,000 comments. You got a highly charged political issue, and the department is going to want to build the best case it possibly can for its final rule. And man, that takes time. And we talked about the fact that they've got all these rules they're trying to get through, and only a certain number of people who can work on them. So I'm doubtful. I'm going to get through this really quickly because I want to hit gainful employment before we're out of time here. But the one thing I wanted to really highlight out of the department's proposal were what I considered sort of extraordinarily burdensome requirements around the management of hearings and cross-examination. Requirements that, again, despite the political rhetoric you may hear, go far beyond anything that even the prior administration included in its guidance. The prior administration did not require institutions to necessarily engage in live hearings, nor did they require institutions to conduct cross-examination in a particular way. This proposed rule does. It actually places a fairly significant burden on schools. So first of all, you would be required to provide a live hearing for formal complaints. So if someone actually says, this is a formal complaint, right? The rule also clarifies that adjudicators should not be a Title IX coordinator or the investigator. And we've seen some federal court cases that have mirrored that attitude of late. But the thing that I really want to focus on is cross-examination. I thought some of this was extraordinary, and I expect that the department has gotten a real earful from traditional higher ed and others about these requirements. So the adjudicator would be required to allow each party to cross-examine the other party and any witnesses. But the rule proposes with great specificity that cross-ex must be conducted by each party's advisor. And if a party doesn't have an advisor present, the school has to provide an advisor. And a lot of people asked, well, wait a minute, what if one party has an attorney? Does that mean the institution has to come up with an attorney to represent the party that doesn't have an advisor? Otherwise, you have this mismatch in terms of the advisors, right? If a party or witness doesn't submit to cross-ex, the adjudicator is not permitted to rely on any statement of that party or witness in reaching a determination. And with regard to cross-ex, and whether you're a giant school, in which case you may have a lot of these proceedings, or a really small school, in which case you may lack resources, I thought this was quite incredible. It says at the request of either party, the school has to provide for cross-ex to occur with the parties located in separate rooms with technology enabling the adjudicator and parties to simultaneously see and hear the party answering questions. Wow, remarkable. I mean, the level of specificity here and the obligations ostensibly being placed on institutions is pretty extraordinary. I mean, the truth of the matter is nobody likes this rule that I'm aware of. I mean, the folks who liked the Obama-era approach aren't crazy about it, and institutions of higher education who would like to largely be left alone or left to manage, sexual misconduct in the way that they see fit, I mean, this is not an answer for them either. So, again, highly controversial rule, and one I hope you guys will be paying attention to. By the way, extra credit, we did a webinar. Some of you may wonder if I just sit around all the time doing webinars. My wife would tell you yes, mostly. That's right. And you should be mowing the lawn is what you should be doing. So we did a Title IX proposed rule webinar last fall, right after this proposed rule came out. I went through this whole thing in great detail. Again, it's available free and on demand if you'd like to listen to it. Okay, so gainful employment. Before you guys in traditional higher ed check out, just keep in mind the gainful employment rule impacts proprietary schools and public or private nonprofit schools that offer non-degree programs that are Title IV eligible. And I know a lot of community colleges certainly, and a lot of even large traditional research universities may have graduate certificate programs that are non-degree programs. All of that stuff is a gainful employment program. So here's what I want you to know. The Great Rescission, right? I'm going to cut to the chase on this. I'm not going to go through a chart and detail the entire history of gainful employment. Here's the thing. So the prior administration promulgated a final GE rule in October of 2014. We just got a new 2019 GE rule, just came out, right? And this administration, and promulgating their final 2019 GE rule that is now out, came out July 1, rescinds the 2014 GE rule in its entirety. Okay, and because the 2019 GE rule will not become effective until July 1, 2020, that 2014 rule is still on the books and will remain on the books until July 1 of next year. However, as detailed in the preamble to the 2019 rule, this administration has exercised its statutory right to designate the 2019 rule, and in other words, to designate the rescission for early implementation beginning on July 1 of this year. Boy, that's a lot, Aaron. What are you really trying to say? What I'm trying to say is you've got a 2014 rule that's on the books, and the 2019 rule takes it off the books completely. That won't officially happen until July 1 of next year. But you as an institution can effectively implement the rescission right away by early implementing or electing to early implement that rescission, okay? The department covered how you should do that in an electronic announcement that it put out on June 28th, just a couple, 3 days before the final rule. And they plainly stated what you should do and what's required to early implement, and the fact that early implementation essentially allows you to take the GE rule off the books, the 2014 GE rule off the books as far as your school is concerned. we did a blog post, and by the way, you can actually click, I think, on these images and it will take you to them, but we did a blog post on doing the early implementation, and we included as an attachment to that blog post here on the right a model document that you can use for early implementation. So you're very welcome if you want to read more about how to do that and you want to look at that model document to get at it. Okay, so just lastly, we do a higher ed webinar series. So this is not actually part of the series. This is just a summer one-off. But we did it last year, and it started in the fall and went through the spring to track the academic year, and we get a lot of people in talking about different stuff, and we do one each month. So if you'd like to look at any of the old ones, you can just click on these links. They're all live links, but please keep a watch because we're going to be sending out information shortly about the upcoming 1920 series. We also, I mentioned earlier, have a blog, and we talk about lots of different kinds of things like gainful employment. I think here you saw we did an article on the Duke's Shoegate. I'm a Duke grad, so when Zion Williams' shoe exploded, I was very interested in that. And the chair of our sports practice actually was kind enough to write that article, Bob Wallace. So now, all of that having been said, I will let's see if we have any questions and answers, and I'll do my best to answer a few here. All right. Let's see. Okay, I have a couple of folks who, so one, I had someone who emailed and said, so Josh Hawley just introduced some federal higher education legislation today. I've not looked at it yet, but anyone who is interested can go out and Google that, and you can probably get a look at it. Also, someone said, go Blues. So thank you, sir. I appreciate that. For those of you who may not know, St. Louis brought home its first Stanley Cup recently, and we were very excited about that. Okay, let's see. What was the first organization you mentioned that does legislative or the regulatory tracking? I mentioned, I believe the first was NASFA, which is the National Association of Student Financial Aid Administrators, NASFAA. And they are the trade association at the national level for all those financial aid personnel you've got at your campuses. And they do a great job. And they have had some folks posting regularly as these various regulations have come along, including the Accreditation and Innovation Regulation. And as I mentioned earlier, I mean, their angle is very much, from the perspective of financial aid administrators. But I think that's great. So you get their angle, and then NACUBO, the National Association of College and University Business Officers, has done a really great job tracking pieces of both the bar defense and the accreditation innovation regulations and talking about how they potentially impact financial responsibility, the treatment of the composite score, things of that nature. So I love their perspective. And then, you've got NICU, the National Association of Independent Colleges and Universities, and ACE, and I mentioned earlier, and they do great work as well. So all of those folks are doing a lot of writing. And, if your guy does what I do, I kind of like to look at what everybody is saying and to compare notes. But a lot of good stuff out there. Let's see. Okay, can you clarify whether the state authorization rule for distance education programs requires that institutions obtain authorization only if the state requires authorization for distance education programs? If the state does not regulate distance education or offers an allowable exemption, a school may offer distance education in that state. Yeah, I mean, that's right. So first of all, if you're in SARA, it's probably not as big a deal, right? But let's say you're not a SARA institution and you're actually sort of going through the process of determining whether or not you have authorization in all of those states where you have students or want to have students and where they would be resident, because remember, under the 2016 rule, it ties to residency. And you come across a state that says, you know what, if you're regionally accredited, and you are so-and-so and so-and-so, we have an exemption. I would get something from them in writing, frankly. There was a time 15 years ago, if you'd asked me this question, and I said, well, if you're confident and you've read the rule, I probably would have said you don't need to worry about it. But these days, my advice would be if you're confident you're exempt, to consider seeking that exemption or getting documentation of it in writing. Ask your counsel. They may take a different view. All sort of depends on your risk assessment. You may not want to reach out to the state if you're extremely confident that you get the exemption. I would be mindful of whether or not the state actually requires that you apply for and secure an exemption. Sometimes that is the case, and that's a little different from, some states even will issue a document that sort of acknowledges the exemption. That's different from a state that just says, if you meet this definition, then you are not covered by our law, right? So there might not be an actual exemption that you have to apply for or maintain. But at the end of the day, I mean, what the department wants to know is that you have done what needs to be done vis-a-vis that state to be authorized by that state. I mean, there can be a wrinkle. I'm not sure you're really asking this question, but there can be a wrinkle. You know, there was when the department first started getting into this idea of state authorization, I mean, there was a time when they said, you know, there are some states that don't have a mechanism for authorizing certain kinds of institutions at all. And that's not good enough for us. You know, if you're in that state, then as part of the sort of fundamental Title IV triad concept, you've got to be authorized to operate, right? So there has to be some sort of acknowledgement from the state that you're authorized. You know, in the context of distance education programs, like this, I mean, I think now most states have put something in place that will get it there. So you can get something from them or acknowledgement from them, et cetera. But you know what, you should talk with your counsel. It is complicated, to be frank. And whether you're in SARA or not complicates things. Whether you're dealing in California or not complicates things. Most people know California is, I think, now they only hold out from SARA. So, you know, you should really talk about it with folks. And one thing I also often recommend when you get into these sort of complicated state authorization discussions, and you start looking at all the states where you do business, I always recommend, too, that you really allow there to be sort of an overlay of a risk assessment. I mean, think about the states where you have lots of students versus, you know, if you've got a state where you only have one person enrolled. I'm not suggesting from a legal perspective there's a distinction in what you're required to do, but there certainly is a difference in terms of the risk that it poses for you as an institution, right? Because in one place you've got a lot of business happening and in the other you may not. Okay, let's see. My understanding is that while the department authorization has been delayed, that does not release institutions of the responsibilities to meet individual state regulations. So I just want to be clear, right now the 2016 state authorization rule is no longer delayed, right? So it is in effect. Let's just be clear about that. And also it's important to understand that your obligations vis-a-vis the department, in other words, what you have to show the department for Title IV eligibility, from a legal standpoint is distinct from what you have to do with your state to ensure that you are properly authorized, right? So even if the department is still waffling around state authorization or changes its view, you know, when the 2019 rule comes out, I mean, it's a separate question whether or not you have to be authorized in a state and whether or not you participate in SARA or don't participate in SARA. I mean, that's a state law question, so hopefully that makes sense. But I think sometimes folks get this idea that, well, if I'm doing these disclosures that the feds require, I'm okay around state authorization. But, you know, whether you're authorized to operate in a state is a question of state law, right? And then whether or not whatever you obtain from the state is satisfactory to the department is a question of federal law. Hopefully that is helpful. Let's see. What do you mean about all of the 2016 state authorization rule is in effect right now? I've just plainly stated the rule that was supposed to become effective July 1 of 2018 is effective. Okay, I'll just say that again. The federal rule, the Department of Education promulgated a final rule for state authorization in 2016. That rule was set to become effective July 1, 2018. It was delayed, and a court found that the delay by the department violated the Administrative Procedures Act. And the 2016 rule that was set to become effective July 1, 2018, every aspect of that rule is now in effect in the law of the land. Let's see. Are online SARA institutions required to provide state complaint processes for every state in which enrolled students live? You know, you should go back and listen to our state authorization webinar that we did last spring. It depends whether or not you have to provide complaint information. Turns actually on whether or not under the state reciprocity agreement, the agreement itself specifically contemplates certain things about how student complaints can be managed. And we actually have a slide in that presentation that speaks to that. I will just tell you, I mean, my advice has been there are a couple of resources out there I've seen where folks have just compiled all the state complaint processes for every state. You know, and if you're an online institution that's in lots of states or every state, I mean, one way to just be sure is just to have a document out there that lists, you know, contact information for students who may have a complaint in any state. You know, part of the reason that's helpful too is, I mean, if you're doing business in California, if you've got folks who are moving from one state to another, you just sort of cover your bases by listing everybody, and it's not that hard. Again, I've seen several folks out there and organizations that have just put together listings of where a student could file a complaint in every state. So that's one way to go. If you don't want to get into sort of the specific language of the 2016 rule and what, you know, the SARA agreement may or may not provide for. Let's see. Under the state authorization rule, when reporting adverse actions, is that only from the federal government and accreditors, or does that include state agencies that regulate professions like boards of nursing? You know, I'd have to go back and look at the rule. But remember, you're not, those state authorization requirements are disclosure requirements, right? You've got the reporting obligations under bar defense that we talked through, but here we're talking about disclosing information, in some cases information that just has to be made available somewhere like on your website, and then there is a small number of those obligations that have to be provided directly to the student. Again, in the webinar we did last spring, we went through a lot of these questions. I'm just going to defer to that webinar, frankly, because we went through a lot of this in detail and actually had a lot of Q&A where we sort of got into specific little nuances around state authorization. Let's see. Let's see, can the 60-day notification, so I think we shifted now to bar defense. We're talking about financial responsibility notification requirements. Can the 60-day notification, which started from that March 15, 2019 date, which is when the department put out that material guidance around financial responsibility reporting, can that be imputed to the June 3rd, 2019 electronic announcement? So I think the idea is, can you start the 60 days from June 3rd? Let me just offer this up. At this point, I mean, you've either reported events that are required to be reported or you haven't. And you know, whether or not you, I mean, I guess if the department down the line, if somebody made the argument that you did not hit the 60 days, you could certainly attempt to argue that the 60 days should run from June 3rd. The other thing is when the department put out its June 3rd guidance, I mean, part of what it acknowledged was there's still a lack of clarity around some of these reporting obligations, and it sort of said, look, you should just get stuff in as soon as possible. I know there was a real lack of clarity around whether public institutions were even covered, and I think there's a very legitimate argument that they should not be, incidentally, and that I know the department there's a lot of discussion around that as well. But setting all of that aside, I mean, you know, whether you could make the argument to the agency or someone that it should have run from June 3rd, at this point, I mean, the main thing is just a report. And I will offer now, and I've said this a couple other presentations, you know, in my mind, the vast majority of what you're going to be reporting to the department almost certainly does not represent a material impact to your financial wherewithal. I mean, all these little settlements of $1,000 or $10,000, it's unlikely for most schools that impacts your bottom line. The real compliance risk here is just not reporting, because under the law, if you don't report things that should be reported, then the department has the ability, at least theoretically, or not theoretically, literally they have the ability, whether they would or not is yet to be seen, but they could initiate a fine, limitation, suspension, or termination proceeding. So they could act against your Title IV eligibility or fine you. Who knows what they're going to do, whether a subsequent administration will be more rigorous. I will say I think it is very possible that you will start to see auditors, whether you're talking about you're an independent auditor doing an A133, or if you're a for-profit school, you know, on the other side of the house, I think those auditors may start being instructed to review whether or not schools are complying with reporting requirements as part of your annual external audit. So that could be one way the department builds in a monitoring mechanism, and one I expect, frankly. But at this point, I think the trick is just try to get it in, and if down the road your auditor or the department argues that you missed the 60-day deadline, I would argue maybe that it should be moved to June 3rd, or more, I think even better, it's just that there was a real lack of clarity around what was required. Let's see. Are the pieces you are sharing on the financial responsibility framework, do they cover all sectors of higher education or just proprietary? All sectors of higher education. The only exception is there are a couple of reportable events that just would not apply to a private nonprofit institution. So there are a couple of reportable events that are specific to public entities. Whether or not an institution complied with the 90-10 rule, that rule only applies to for-profit institutions. But if, unless one of the reportable events is just an event that would not apply to a private nonprofit or public entity, then everyone is covered, right? Let's see. The borrower defense rule is for student loans only. Well, borrower defense claims, to be a borrower defense claim, it has to be a claim that relates to, so if you're attempting to get your loans discharged, yes, what we're talking about is your federal loans discharged, not any type of private loan. And so a borrower defense claim has to be a claim that relates to the discharge of those federal loans, if that's what you mean. Let's see. So any notification of a legal action would be covered as an event that has to be reported. For example, an EEOC action by a former employee. I don't think if you have an EEOC action that you would have to report the action itself initially. I don't believe that qualifies as other qualifying litigation because it is litigation. But if you have a settlement that results from an EEO proceeding, that would be covered because that is a final judgment or a settlement resulting from an administrative proceeding, right? And by the way, settlements don't even have to stem directly from an administrative proceeding. The department just wants to know basically if you paid something out. But in terms of whether or not you have to report the filing of the claim, no, you have to, my view is, you should ask your attorney, but my view is you have to file agency BDR litigation. So if you're being sued by a federal or state agency for a bar defense claim, or if you've got other litigation, so you're being sued in an action in court. So somebody just files an EEOC claim, I don't believe there's any obligation to report that. But again, if you have a settlement to make it go away, that would ostensibly be covered. Does this mean our schools should redo our sexual harassment policy? So I think we've moved into Title IX. Not yet, okay? So the Title IX rule is just proposed, and there is lots to think about, and it's very politically charged, as I mentioned earlier, and we have no idea what the final rule is going to look like or when it will become effective. But if and when the department does promulgate a final rule around Title IX, 100%, everybody on the line is going to have to reevaluate their sexual misconduct policy, their annual security report, their student employee handbooks. Everywhere you've got information that talks about the management of sexual misconduct on campus, you're going to need to revisit it. The other thing is, keep in mind, you've also got to reconcile all those policies with any applicable state laws. And some states, New York being a great example, has a very robust law that is specific to the management of sexual misconduct at institutions of higher education. Can a Title IX coordinator report to an adjudicator within an organization? The coordinator's manager is the adjudicator. Probably not great. Probably better if your adjudicators and investigators could be independent of that reporting line, right? Because you could ostensibly have some type of conflict of interest there. Right, so just for the sake of creating independence, probably better if it doesn't work that way. I don't know that I've seen any rule or statute or guidance that strictly prohibits it, at least not at the federal level. But there is a lot of concern around conflicts of interest. That's why the department in its proposed rule wants adjudicators and Title IX coordinators to be different people. And so, I think if you've got reporting lines between those people, you start to get right back into issues around conflict of interest. Let's see. Is there a reason a school wouldn't early implement? Now we're talking about gainful employment. Well, it's hard for me to imagine a reason. I mean, unless you just feel like the information in the gainful employment disclosures, there's no reason to report information, right? I can't imagine the department's really going to do anything with it at this point. You're required to under the law, by the way, if you don't early implement. But my expectation is most schools will early implement, so it's just hard for me to imagine sort of those machines are going to continue to move forward. If you felt like the gainful employment template or disclosures were extremely meaningful, you could voluntarily or you could choose not to early implement that. But my experience is most schools do feel like it's very useful to give information to prospective students, but most schools, in my experience, also feel like they can do a better job designing that information and presenting it in a way that is more meaningful than what's supplied in the gainful employment template. So, frankly, it's hard for me to imagine why most schools would not want to early implement. Let's see. Okay, so I have some sort of specific questions I'm going to skip here. Just specific, to particular schools. What individual disclosure requirements will remain when the 2019 state authorization rule becomes effective? Well, I don't know yet. I haven't. We don't have the final rule, but it sounds like the department's intention is to to ditch most of the disclosure requirements, and then to move the ones, particularly those dealing with professional licensure, just into the general area or the area of the federal regulations that generally relate to the disclosure of consumer information, right? But most of that is not direct disclosure. Most of that is, quote, make available disclosure. I don't know what the department's going to do in the final rule in terms of whether it's still going to want certain types of direct disclosures to be made. Great question, though. Concerning bar defense, how far back must schools go in reporting claims? Look at our reporting guide. It's really specific, right? So the rule's in effect from July 1, 2017 to present, but there are certain circumstances where you don't have to report things that may have occurred, either because they were, like if you had a settlement, just by way of example, if you had a settlement you paid out, but you paid it out in a time period that's covered by one of your audits that you've already submitted to the department, you don't have to resubmit that you paid out that settlement because essentially it's already been captured in information that was given to the department. Similarly, certain litigation, if it had already been resolved prior to March 15, 2019, you may not have to report. But boy, you should really look through. Like I said, we have a chart that's available on our website. If you can't find it, let me know. I'll send it to you. But it's just all really specific, so I hesitate to sort of generalize. All right, and that was the last question. So thanks to everybody who stuck in for the questions and answers. I hope everyone has a great week and weekend, and keep a lookout for our upcoming higher education webinar series information.